SJC-12133, Commonwealth v. Eugene, R. Tate.
Thank you. Ms. O'Brien, please. We have to unmute Ms. O'Brien.
May it please the court. The Commonwealth in this case, the prosecutor, I should say specifically, the trial prosecutor, included two arguments in his closing that were completely unsupported by the evidence.
Well, wait. Before you say completely unsupported, can what about the, let's talk about the first argument, which is the bullet, right?
Yes.
And if you look, when I read Sergeant Sullivan's testimony, it seems as though, to me, I know the prosecutor got cut off and there were objections and some of what the prosecutor wanted to elicit did not get out. However, the sergeant did say there was a different, he explained that a lead bullet without a casing would be or without a jacket would be very soft. I thought maybe on page 145, 146, 147, that there perhaps was enough there to support this argument.
I don't know what you're referring to tell you the truth on those particular pages, Your Honor, but what the ballistician testified to is that this particular bullet, because it had a brass casing, was less soft, less malleable than, and I'd suggest also that the other thing that for whatever reason, the ballistician never testified to is what type of gun this bullet was testified.
Yeah, but that doesn't have anything to do with that oral argument, does it?
It certainly does, Your Honor. The lack of that knowledge, what the prosecutor argued was that this bullet, and I'd ask the court, I'm asking the court actually for two reasons in its plenary review of this case to examine that bullet.
We will, counsel. We always exhibit.
And there are two reasons for that. The first reason is that it's not accurate to say that that bullet was undamaged. You can see by the tip of the bullet, and this is possibly the less important of the two reasons, but you can see that the tip of the bullet is smashed. It's not undamaged. You can see that there was damage to the bullet. But I say that's somewhat less important because the jurors could just look at that bullet and they could see the damage there. They could see that it was gouged at the front. But the second reason is that in looking at the bullet, the Commonwealth has suggested that just by looking at this bullet, the jurors would be able to see that it could not have caused the damage to both of the victims in this case. And that's simply, what you'll see is that that's simply wrong. This is not a matter of common sense. The jurors could not look, the jurors could look at that projectile all day long, and they would be no closer to understanding whether or not that bullet could have caused the damage to both of the victims in this case.
Where are the victims positioned in relation to each other? The person who's killed and the other person, where are they in relation to each other when the shooting happens?
The victim is somewhere behind, according to the testimony, the victim is somewhere behind Mr. Fiume, who the bullet hits first. So the bullet goes through Mr. Fiume and hits hits Mr. Puopolo and kills him. That's what happened here.
What I'm asking, so they're right behind, they're standing right behind each other, or are they, when we read the record, my recollection of this, but needs to be revised here, but my understanding is they're not next to each other or right behind each other when this happens, but that's but you tell me, because we're going to go through that.
Well, it's one of the problems here, Your Honor, that there's no way of, from the testimony, there's no way of knowing exactly where they were. As the jurors were correctly instructed by the judge, the human memory does not work like a video recorder. So we don't know. There's variation in the descriptions of where the two individuals who were shot were. It depends on which of the witnesses you're looking at. But it seems fairly consistent that Mr. Fiume was...
Remember, the Commonwealth can argue from descriptions that it thinks is credible. It doesn't have to adopt your version of things, right? As long as there's evidence to support the idea that it's, ridiculous to say that one bullet, killed both, went through both of these individuals, they get to do that, don't they?
Well, they get to do that based on the evidence that the jurors actually heard. They don't get to pretend to expertise. They don't get to give expert testimony in closing argument, which was what was done here. When the prosecutor stated this type of bullet, quote, goes into the body and it stays there. There was no evidence to support that. What he was trying to say is that this type of bullet, this bullet could only have killed Mr. Puopolo. It could not have gone through the body of Mr. Fiume and then killed Mr. Puopolo. There was no evidence of any kind to support that. That was highly improper. And the judge recognized that. The judge specifically stated when there was an objection, stated to the prosecutor there was no evidence given to support that this type of bullet could not have created the damage to both of these victims. So it was highly improper.
Well, wait. That's a little bit different than saying the same bullet. You said the type. Was he saying the same bullet? There's no evidence the same bullet couldn't have done it? Or was he saying, referring to this type of bullet?
This type of bullet.
Okay.
That this type of bullet could not have done that. And that's not a matter of common sense. I would suggest, it's certainly proper for a prosecutor to call upon a juror's common sense. But what was common sense here really is that we don't know what type of gun was used. So we don't know what amount of power was behind that particular projectile. We also know, and it's not contested, that a bullet did go through and through Mr. Fiume's body. And we know that it didn't just disappear into thin air. And this was an enclosed area. It was carefully searched by not one, but two ballisticians, not to mention the other personnel that were there. There was never a bullet strike found. The projectile itself was not found. To this day, there was no evidence whatsoever of a second bullet, none, beyond the testimony of two witnesses who were impeached, one of whom admitted during cross-examination that he had perjured himself when he said he saw Mr. Tate fire a bullet.
The defendant's closing, I'm trying to remember, talks about one bullet going through both people, right?
Yes.
So it's this type of bullet thing is not the argument that was made, but rather that one bullet went through both, right? The single bullet went through both, right? Or am I
Well, that was certainly defense counsel's argument, and there was absolutely nothing in the facts of this case that were legitimately before the jury to rebut that theory. That was a solid theory.
Well, but that's why what the Commonwealth is doing is we have a lot to rebut that, which is we have testimony that there are two shooters, right? We have direct testimony that there are two different shooters and they're shooting at two different people, right?
There were two witnesses who testified to that. One was Mr. Fiume, who testified to that and then admitted during cross-examination that he had just casually perjured himself in his direct examination because
But on whether or not there's any evidence, what you started out with, that is some evidence. You may not like it, but it's some evidence to support what the Commonwealth had to say.
Well, to that extent, yes, I'd have to say, Your Honor, I've never argued insufficiency of the evidence here. My principal argument is that the prosecutor went far beyond what the evidence in this case would have allowed by testifying that projectile could not have caused the damage to both of these victims. This is what he testified to.
Ms. O'Brien, what about the import of the curative instruction?
The curative instruction was just the generic instruction that's given in every case. It's something to the effect of it's your view of the evidence that controls, or some standard generic instruction like that.
Was that the one requested though?
Defense counsel did not request an instruction beyond that. And as I've said in my brief, it really should not be the burden on defense counsel to be able to come up with a cure for every overstep by the prosecutor.
But they're supposed to object, aren't they, at the curative instruction if they don't find it satisfactory?
I've never read that. I have certainly read that it's an advantage if, I'm aware that it's certainly an advantage if defense counsel can think of a specific argument.
But doesn't it signal, you have a careful trial judge, you have an objection, and you'll get to the next one, I'm sure, to two parts of the closing argument. One gets the general instruction, one gets a specific, don't consider that instruction. It kind of signals that the defense attorney, who's also incredibly experienced, considered the second one really bad, and then the first one, he said, it'll be cured by the general instruction.
But
it goes to the gravity of the harm, I guess.
Well, Your Honor, I think, again, as you say, very talented defense attorney, but I think what I would have to say could have cured this if the judge had asked the jurors to specifically disregard what the prosecutor said about the bullet not being capable of causing a through and through wound. There was nothing to.
But it's not a matter of common sense. If you look at a bullet that's somewhat pristine, I mean, it obviously was lodged in the body, and say, you know, it wasn't deformed like you'd expect if it went through this ride. It's like the magic bullet theory from the grassy knoll.
But it's, Your Honor, it's a brass jacketed bullet, what some people refer to as I don't want to be going beyond what but it's a fully jacketed.
I'm aware of the ballistics evidence, right?
Yes. Yes, you're. So for the prosecutor to say that, I mean, if he had evidence, if he had an expert to say that, that would be one thing. But for him to pretend that he can say that this bullet, that the bullet could not have caused a through and through wound, that's simply incorrect. And the positions of the parties, I'd like to get in. There's nothing about the positions of the parties. If the deceased victim had only been leaning forward just a little bit, the angle would be correct. There's nothing in the case that would suggest that he was standing bolt upright. If he was merely leaning forward a little bit, the angle would have been correct. So I'd like to point out that this was a critical issue to both parties, that both parties were concentrating on this during their direct examinations, during their examinations of the witnesses, and both knew it was critical because there was a possibility that the jurors could convict of second-degree murder only, and that the difference to Mr. Tate was enormous. It's the difference between his going before the parole board at age 34 or dying in prison, an old man.
Before you run out of time, could you address briefly the second closing argument issue, and then lastly the manslaughter instruction issue as well? I don't want you to get stuck on just the first issue.
Yes, thank you, Your Honor. The prosecutor in the second issue imagined what the two robbers were thinking or saying to each other. This was purely a matter of the prosecutor's imagination. There was nothing to support it. He imagined that the two were saying to each other, kids from the suburbs, they don't handle the streets. I'll pull a gun on him, he's going to freeze. Nothing in the evidence to support that.
And that's the one that Judge Tutman said, don't consider that.
She said, don't consider it. She said, don't consider where they're from. But I'd suggest that what's more offensive about that argument is the assumption that's behind it, that because these were two black men, that they would be of the streets. You would not see that type of assumption if these had been two white robbers. So the suggestion you get there that these are two black robbers who are targeting people from the suburbs, it's highly improper, it's offensive.
Ms. O'Brien, I understand that. And I agree that we should be condemning that kind of, dog whistling if that's what was going on here. But there was no back and forth on that point. I read the trial transcript on that. The racial component to that was not raised in any way before the judge. Actually, the instruction the judge gave was exactly the one the defendant wanted, wasn't it? So I get your point generally, but that wasn't how it was presented to the judge at all.
That's true, and I acknowledge that, Your Honor, and I'm still asking that the court consider that aspect of the argument.
What about the curative, the part of the curative instruction that says that Medford is also a suburb as is Stoneham, so equating the two places?
Well, Your Honor, these were of course Middlesex jurors, and they would know that that Medford is a city, and Stoneham is a suburb. Medford is a city in every sense, and I'm not sure that really is the crucial aspect of this. It's just the assumption that these two men, because they were Black, are of the streets. Mm-hmm. And I acknowledge that it's much easier for me to sit here and say, you know, not having to look at the prosecutor and say, hey, you know, that sounded pretty racist. I wouldn't have to do that.
What did the defense attorney say that prompted the prosecutor to retort?
I didn't see anything that.
I thought there was some fire with fire in that.
Didn't he describe
the defense attorney did predict that would be said, and maybe, as you've said, this is a very talented, very good defense attorney. Maybe a better tactic would have been a motion in limine, since he knew this was coming, but he didn't do that. So that's in a way, you know, I don't mean to be, as I say, critical of defense counsel. He did an excellent job, but that would have been a better strategy than predicting what was going to be said.
Didn't he describe them as like the drug pins of Stoneham? That Mr. Fume was the, you know, primary drug dealer in Stoneham, and these were devious drug dealers. Wasn't there some of that going on?
Well, yes, there was, and I think there's an argument that's been made by the Commonwealth that house somehow justified the comment. I don't follow the argument. I don't know how that would have justified a comment like this.
And can you move to your manslaughter argument as well?
Yes, I have to say, with regard to the manslaughter argument, I relied and basically repeated the argument that was made by defense counsel at trial. I thought he did as good a job as could be done with that, and I used his argument and repeated it. And my argument there is that what I'm hoping the court will consider is that he preserved Brown, because the gist of the argument that there should have been a manslaughter instruction is that there was not sufficient evidence of malice, because manslaughter is, of course, murder absent malice. So I'm hoping the court that would consider that by making that argument, he preserved the Brown issue here, that there should have been an instruction that a showing of malice was required. If I could make, I think I may be over time. For some reason, I can't see.
No, you have about 2 minutes left if you want to sum up or make a last point.
If I could just return very briefly to the previous argument, I know that I stated that was referred to that second argument as a collateral matter. By that, I did not mean in any respect that it was less important. An argument that related to or improper testimony that relates to a collateral matter can be highly damaging. I'd give as an example, if somebody testified, well, I happen to hear that this defendant has committed many crimes in the past. That would be entirely collateral and yet obviously extraordinarily damaging. So I did not mean to suggest by saying that this was collateral that it was not highly damaging. I was not conceding that at all.
Can I ask, before I lose you, you want us to reduce the verdict?
Yes.
And
if you don't read
the level of his participation in this is when we read through this transcript, he's the one who's at each of the different dealings, right? The guy who, the other shooter isn't there. So can we really consider him sort of as a more peripheral figure here? Because it looks like he's driving the drug deal, this guy.
Well, in regard to my argument for reduction, I was arguing more, Your Honor, that I pointed out that he was 19 years old at the time. And also I asked the court to consider the unfairness of the prosecutor's closing. I think those were the two main things that I asked the court to consider.
Thank you.
Thank you, Your Honors.
Thank you, Ms. O'Brien. Ms. Russell, please.
Thank you. Good morning, and may it please the court. Assistant District Attorney Lindsay Russell for Middlesex on behalf of the Commonwealth. I just want to step back a bit and provide some basic facts that were in evidence. And just for clarity of reference, I'm going to refer to the victim who was shot but survived, Mario Fume, as the injured victim, and to the victim who was shot and killed, Joseph Popolo, as the decedent. So during the second encounter that night between the defendant and his co-defendant, Jesse Williams, when the shooting actually occurred, it is admittedly a bit confusing where everyone was standing in that room. However, there are a couple of important facts that were clear from the testimony and the medical records. So as Your Honors acknowledged, all three eyewitnesses saw the co-defendant Williams pull out a gun and point it at the injured victim, and saw this defendant pull out a gun and point it at the decedent. The evidence also showed that the shot to the injured victim went into his middle chest area and exited in his back about 6 inches above his waistline, and thus exiting lower than where it entered in a downward trajectory. And that the gunshot wounds to the decedent were in his upper left arm shoulder area and then into his upper torso, with the bullet landing in his lower right chest cavity.
Counsel, what do we make of the fact that the second bullet was never recovered?
Well, there was the bullet that was recovered, Your Honor, was from the decedent's chest cavity. And that is the same person who all three eyewitnesses saw the defendant standing in front of with a gun pointing it straight at him. With respect, there's plenty of reasons why there might not be another bullet or shell casing and if you look at the exhibit attached, I believe, to the defendant's record appendix, this is a room with a lot of things in it, and it is a small space. However, there were plenty of people even right after the shooting who are walking in and out of the room. Obviously, there was some nefarious hiding of drug evidence that was going on. And again, there were many officers and other civilians in and out of this room. Things can be kicked around. And I believe the ballistician did testify about how that can happen in crime scenes where they don't always recover everything. But just back to my first point, however, about where the positions where everyone was, with the decedent standing at 5'9", what the prosecutor was attempting to point out there is how implausible it would be for that same one bullet to have gone through the injured victim in a downward trajectory to then somehow enter a 5'9" tall man's upper shoulder area, where there was no view of the evidence that could show that the decedent was doing anything other than standing in that room. And in any event, the defendant's contention that there was no evidence of 2 gunshots is just incorrect. In addition to what I just stated, there being 2 victims with gunshot wounds at the scene, the 3 eyewitnesses who saw each pull out a gun at each victim, there were also 5 entry and exit wounds between these 2 victims. And again, there was the physical evidence that I'm sorry, Justice Cipher.
No, I was just thinking 5. I was thinking out loud quietly though. 5. I was counting the 5. Sorry.
Yes, it was a through and through on the injured victim, and then on the decedent there was a through and through almost in his upper shoulder into his torso. So 1, 2, 3. And right. So while there was also evidence of only 1 gunshot, namely that being that, as Your Honor mentioned, there was 1 bullet recovered, and that the 3rd eyewitness, George Tate, said he heard 1 gunshot as he ran from the garage, and the injured victim's stepfather, who was upstairs, had heard, he said, a gunshot. That does not make the considerable evidence or the reasonable inferences that can be drawn from the considerable evidence that there were 2 gunshots any less reasonable. Now, with respect to the prosecutor's specific remarks about the damage to the bullet, while it is true that Trooper Sullivan never actually testified to the amount of damage on that bullet, However, in the entire context of the closing, it's clearly that remark was not prejudicial. Even defense counsel, as Your Honors pointed out, predicted that the prosecutor would argue in closing that that bullet had no damage. So clearly he viewed the evidence as something where he thought the prosecutor could argue based on reasonable inferences that there was no damage. In fact, he stated, the government will say, and just to predict a little bit about what Mr. O'Reilly, the prosecutor, is going to argue to you, that the bullet isn't damaged, the slug isn't damaged enough for all this activity. Think about the different things that people have said about the positioning about where Popolo and Fiume was. So clearly this was something that at least according to the trial attorneys, the people that were actually there at trial, believed that this was a reasonable inference that could be drawn, such that defense counsel even brought it up in his closing. And most important to note with respect to this issue, and underlying really all of these issues, and showing that this statement did not go to the heart of the case, is the fact that the Commonwealth never had the burden of proving that the defendant actually fired the shot that killed the decedent. This was tried at the outset as a joint venture in which either defendant could have been the principal shooter. To the extent that the defendant argues these remarks go to the heart of the case because they bear on the credibility of witnesses, that just has no merit here. This isn't a situation where the prosecutor improperly bolstered testimony, again, resulting in prejudicial error. First, as explained, there was considerable evidence of 2 gunshots outside of any visible damage to the bullet. Second, with respect to the eyewitness testimony, the injured victim, as counsel pointed out, actually admitted on cross that he had not actually seen the decedent get shot. And in fact, it was the decedent who told him that both he, the decedent, and the injured victim had been shot. And one of the 3 eyewitnesses, Tate, as I previously mentioned, said that he only heard 1 gunshot as he ran away. So clearly that would support the defendant's theory, and therefore these remarks would not have improperly bolstered his testimony. And again, this is an eyewitness who, prior to running away, saw the defendant and the co-defendant each point their guns at the 2 separate victims. And not only that, but the judge did ask defense counsel outright, what do you want me to say? And he said, I want you to remind the jurors that it's their memory that controls. And then she also gave this instruction, the instruction that arguments are not evidence, which the defendant acquiesced to. And I think as Justice Gaziano points out, I believe that that kind of just goes to the gravity of, clearly in the moment, this was not something that everyone was thinking was in any way, and nor should it be viewed now as prejudicial. And in similar lines to going to the prejudice analysis really with this argument, and I'll get to the other closing argument issue as well, is that clearly the jury didn't get carried away here with prejudice. The defendant was acquitted of armed assault with intent to murder the injured victim, as well as assault and battery with a dangerous weapon causing serious bodily injury. So clearly this was a situation where the jurors were carefully scrutinizing the law and did not even find the defendant guilty of all the charges that were presented. Now, with respect to the other closing argument issue, ripping off kids from the suburb as it was presented in the defendant's brief, obviously that was inartful and should be avoided. And however, whatever the intent of the prosecutor was with that characterization, again, there was no prejudice here, where the judge provided immediate curative instruction telling the jurors that they should derive no negative inference from where the defendants were from. And also she basically told, as Justice Seifer points out, told the jurors to equate Stoneham and Medford as the same. So despite any preconceived notions that these Middlesex residents might have about the 2 towns, there's plenty of case law that says, that the jurors are presumed to follow the judge's instructions, and they were clearly told to treat these 2 places as the same for purposes of their analysis of the evidence. I would also just point out
that the curative instruction didn't go to the harm.
I'm sorry, Your Honor.
The curative instruction didn't address the danger and the harm of the closing.
Well, I think it did, because specifically the judge explicitly pointed out you should not draw any negative inference. That inference being that these kids from Medford are, in some way more, because they're from Medford, they're more dangerous, and than these angelic kids from the suburbs, and that they were just basically taken, that these defendants were taking advantage, these Black defendants were taking advantage of these white kids. And I'll note, as I believe Justice Caffer pointed out, race was not brought up at that point as being the issue by defense counsel, at least. However, I can see how, there can be coded or dog whistle language here, which is why I definitely would suggest that avoid it. But I also suggest that the curative instruction cured it. I would also note that during voir dire, defense counsel specifically asked certain questions to be asked of each of the jurors. That goes to the race issues here. Those questions were: the defendant is a black man and the deceased, both the deceased and the victim who was injured are white men. Would this in fact interfere with your ability to be fair and impartial juror? And the other question was, do you have any bias or prejudice against people who are African American? And each juror who was chosen said no to both of those questions that again were requested by the defendant during voir dire. So in a sense, these jurors were essentially pre-screened for racial bias, making them less susceptible, I would say, to any sort of coded language that might have been inadvertently put in there in the closing by the prosecutor. With respect to the manslaughter instruction, there was absolutely no view of the evidence here that could have supported a manslaughter instruction, regardless of whatever sporting equipment might have been in the garage or what may have happened earlier in that night. The judge correctly determined that there was no basis for it, and nor is there any merit to counsel's claim regarding preserving a Brown issue before Brown was decided. This court has been explicit in that Brown is prospective, and only for future trials. And in any event, the Commonwealth really did show actual malice here. This was a situation where even taking the view in the light most favorable to the defendant, that the defendant didn't actually shoot the victim, the decedent. This was a defendant who planned all these, as Justice Kafka pointed out, he was there both times. He's the one who set up the drug deals and the planned armed robbery. He walked into an occupied house carrying a loaded firearm with the intent to commit a robbery. And that is clearly third-pronged malice. And also, I would just note that a second-degree murder instruction was given so that the jurors could have returned a verdict under second degree. But obviously, I think the evidence of felony murder here was overwhelming, so they didn't need to reach that. And then just respect to the reduction pursuant to 33 for the same reasons, where at a minimum, the defendant planned, was present for, and actively participated in an armed robbery by pointing a gun that he had brought at the victim. This case is far from a Brown type case where a reduction to second degree is just not warranted here.
Any further questions for Ms. Russell?
Thank you.
If there are no further questions, then I would just rest on my brief.
Thank you, counsel.
Thank you.